How much into the details do courts get in terms of setting parenting schedules?
Oh,
if the parties can't agree?
Entirely.
Okay.
That's it. That's what we do now.
Okay.
That's absolutely, we talked about custody. It's not about that anymore. It's not about a custody determination.
Mm-hmm.
Let's just walk in with joint custody. Let's think about, we're walking in with joint custody. Then what's the parenting schedule going to be? So what that great determinant is now is just a party's work schedule. Really, I mean, and the first shift, second shift, third shift, are you on salary? How much do you travel? Are you in the country, out of the country? Are you in state? Are you in town? What's fascinating to me is the fights that occur over where the child's going to spend the night and that the child is asleep. I still don't get it, but some people, I've had clients come in with notebooks and graphs and charts about the actual hours that they have. I mean, down to minutes.
Wow.
These are the hours that I have and I want. These are the hours that I have and I want. These are the hours that are available. These are hours that aren't available. It's really interesting. They're well prepared. I don't know how well it really plays with the court. I don't think, we haven't talked about fitness and we haven't talked about fit parents, and back in the sole custody days, fitness of a parent was huge. We litigated the fitness of a parent all the time. We don't really do that now, unless there are the issues that I talked about before.
Right.
Fitness, it's presumed that both parties are fit, and it's presumed that they can both parent. So how are you going to get a schedule?
Right.
And if you know, as a party coming into a case, because you probably do, you read the papers, you read the internet, you've seen cases, your friends, cousins, sisters, uncle got this in his case, so you should get this in your case. So they know about halftime. As much as great as the law is when it comes to making determinations about families, these people are guinea pigs. I mean, not purposely, but that's really what it is. When you start a new part of the law and you start changing from sole custody, shift from sole custody into joint custody, and you start these parenting arrangements that were every other weekend, then they were every other weekend overnight, and then they were, okay, one night a week and every other weekend, and then 2 nights a week and every other weekend, and then a 3-4 schedule, and then a 5-2 schedule, and then a week on, week off schedule. And all of these different arrangements that the courts have basically created, and with, they go to judicial college, there's psychological input into all this. But when I started, it was about meaningful time, that a parent, dad, I mean, there's no reason to mince word, parent, dad, if he had the child on a meaningful basis, enough for them to form a bond, especially in the early years of the child's life, then that was sufficient. Completely the opposite now. Completely the opposite now. And what changed? Did the law catch up? Did we force the law? I mean, what changed there?
Right.
And so a meaningful bond now is a lot different than a meaningful bond was then. And I remember one judge in particular coming in with new statistics. This time is what the meaningful time is for this father, and this is what I'm going to give. And it's just a totally different world out there now.
So